for scheduling.
Scheduling and directions.
For scheduling and directions,
Yeah.
to be given by this honorable court.
Perfect. That was the position.
Yes, my lord. But
So,
yes, my lord.
yes.
My lord. You can ask for the record.
Are you saying, Council Kwako, that I don't have some
Concerns to raise, my lord. And an application to make, my lord.
About what? Just the key. Application about what?
Recusal, my lord.
It is a ruling for recusing this application.
Yes, there are issues that are not canvassed in that area ruling.
Come again.
There are issues
Yes.
that were not canvassed in that area ruling, and I don't intend to repeat those issues that you addressed in that ruling, my lord.
Under which law now, after recusal ruling, under which law are you moving forward again?
My lord, it's the Constitution. The Constitution.
Let me capture this. So the
Relate, my lord, to,
yes.
if I may highlight the
Relate
issues.
to what?
Recusal, my lord.
Okay.
It's about recusal.
Just wait.
And it is, my lord, a new application, a fresh application for recusal, which is allowed under the law, my lord.
Under which law? Yes,
The
yes.
Constitution, recusal of judicial officers, practice directions,
Yes, under
2019.
which rule are you invoking?
Rule 6. I have, my lord, two rules
Yes,
or
wait.
regulations.
Read rule 6. Verbatim. Read rule 6.
Yes, rule 6, sub rule 3B.
Rule 6.
Sub rule 3B.
What is the title of that?
My lord,
May I know who has come?
Richard Vumbuka, Chief State Attorney, appearing together with my colleague Joseph Chomuhendo.
Together with who?
Joseph Chomuhendo, also Chief State Attorney, for the respondent.
Joseph who?
Chomuhendo, for the respondent.
This Council Kwako. Moving court under
3B
B?
of rule 6,
Yes, yes. What is it saying?
where it comes to the knowledge of the judicial officer during the course of the hearing, that for any reasonable cause he or she cannot continue handling the matter, the judicial officer shall state or record the reasons for recusal, notify the parties, and return the file for reallocation to another judicial officer.
Council Kwako, I handled that in my ruling.
No, my lord, this,
handled that
this,
in my ruling.
this rule is very wide. It provides
handled
for
that.
any reasonable cause. And my lord,
Read 8. Read rule 8.
rule 8,
4.
4,
Yes.
where a judicial officer declines to recuse himself or herself, the reasons for declining shall be noted on the record, and the matter shall proceed for hearing. My lord, the issue here,
No, I just, I'm trying to highlight, harmonize with you. This, I have looked at 6, we have read 6.
yes,
3B.
3B.
And I am saying we considered that in my ruling, and I'm telling you to address yourself on 8.4. I gave these reasons.
My lord,
Yes.
I will also draw your attention to that rule 8 you are talking about, my lord, some
Yes.
rule 1.
Read it.
A party who seeks the recusal of a judicial officer under paragraph 7 shall by letter copied to all the parties and the registrar of the court or orally in open court in the presence of the parties request the judicial officer to recuse himself or herself.
Perfect. And
Yes.
I'm saying this one, we invoked it.
My lord, there is no limit to...
Go to 8.5. I have finished 8.4. Let us address ourselves, Councillor Favo, to 8.5.
8.5,
Read it, Baba.
where a party is dissatisfied with the decision of a judicial officer not to recuse himself or herself, the party shall state the reasons and the hearing shall continue.
What is your take on that?
My lord, we are going to state the reasons why we are dissatisfied with your ruling.
Go to 9.
No, my lord, 9 is about to appeal.
Read it verbatim.
Any appeal arising out of the failure to grant an application for recusal shall be made after the matter has been determined.
Yes.
My lord, here we are not raising an appeal. We are raising a fresh application for recusal, which is not allowed, prohibited under the law.
And I'm asking you, under which law are we moving?
This is what I'm saying, my lord. Rule 6 allows as many applications as possible.
Where are you getting that allows many applications?
Yeah, that's what it says. If you have, my lord, if you looked at sub-rule 3B, it is wide. It talks about any reasonable ground, my lord.
Which I am saying...
That is sub-rule 3 of rule 6. Sub-rule 3B of rule 6. It gives us wide latitude, my lord.
So let me, you are invoking rule 6?
Rule 6, 3B.
Relating with what? Recusal.
Recusal, and you have reasons which are totally different from the reasons that were canvassed in the earlier applications, which are captured in your ruling.
You have what?
We have reasons and grounds, my lord. We have grounds for recusal.
Grounds for recusal?
Yes. Which are totally different from the earlier grounds that were canvassed in that application that you disposed of.
You have grounds for recusal which are what? Different?
Which are totally different from the reasons that were canvassed in the earlier application that you disposed of. And this is a fresh application on fresh instructions.
Which are fresh?
Yes.
Application?
Yes.
With instructions?
Yes, my lord.
Application for recusal.
For recusal, my lord.
You can sit, Councillor Kwago. I just want to look at this. You can sit.
I thought I was going to be permitted to proceed, my lord.
I am saying you can sit.
Yes.
I want to respond to what you have raised. But you sit.
If I may finish the submissions, my lord, on that particular argument.
No, the issue here you are saying you have an application for recusal to raise which is different from the former, isn't it?
Yes, my lord.
Yeah, so you sit. I just want to respond to this.
In response to the submission of our senior colleague, the application my lord is seeking to make was already hard and determined. It doesn't matter whether it has a different reason. And in fact, the respondent has been on record to argue that this is an abuse of the process. We cannot have the same applications over the same matter, same parties, seeking the same remedy. That said, even if it were not an abuse of the process, my lord, my senior colleague is relying on Rule 6, Sub-Rule 3B. And my lord, from the reading of the rule, senior counsel has no locus to make an application under that. This rule only applies to a judicial officer. Allow me, my lord, read it verbatim. Where it comes to the knowledge, of a judicial officer.
You are reading
Rule 6,
3A.
3B. The application is being brought under 63B.
Yes. Which one are you reading?
I'm reading B.
Okay.
3B.
Yes.
Where it comes to the knowledge of the judicial officer during the course of the hearing that for any reasonable cause he or she cannot continue handling the matter, the judicial officer shall state on record the reasons for recusal, notify the parties, and return the file for reallocation to another judicial officer. The English is very plain and clear. It baffles the respondent, therefore, to hear the applicants premise the application on a rule which doesn't give them space. Application or matters before court are premised on the law. There must be a provision of the law that allows one of the parties to institute any application before court. And therefore, my senior colleague should have looked or should have premised his application on another rule, not Rule 6, 3B. In the circumstances, my lord, it is our prayer that you be pleased to dismiss the application and the main application proceeds.
Yes, Counsel.
My Lord, for senior counsel to impose this rule on you, my Lord, it is on your own initiative, evolution as a judicial officer.
Here, Counsel Papa. Yes, Counsel.
My Lord, I've failed to make head and tail out of this in submission.
Just to respond if there is nothing.
Yes,
to
I'm
respond.
responding, my
Yeah.
Lord. And indeed, this is what I'm doing, my Lord.
Yes.
Because the reading of this rule is clear.
That is 6.3b.
63B, the reading is very clear.
Okay.
For clarity purposes, let me read it again.
No, I have it. Just, I have it.
No,
Yes.
for myself now, to substantiate the argument I'm going to make. Where it comes to the knowledge of the judicial office during the course of the hearing, that for any reasonable cause he or she cannot continue handling the matter. How does it come to the knowledge of the judicial officer in the course of the hearing if you do not permit a party to bring those matters to your attention?
So you are
I am here to bring those matters to your attention,
okay.
so that you make a decision that you cannot proceed with the matter. So how else would you know that there are reasons that would bar you from proceeding with the hearing of the matter unless I'm given an opportunity to present the same to you? That's why I'm not making head and tail out of it. That is, submission is illogical. It is illogical. Secondly, my Lord, I need to reiterate the earlier submissions I made, that this rule is very wide. For any reasonable cause, that would bar the judge from proceeding with the matter. It's open-ended, it's wide. And my Lord, this has to be read and interpreted against the provisions of the Constitution which grant liberty to any party to raise a matter before a judicial officer. The right to be heard. I don't know why a party to these proceedings would be prohibited, would be barred from presenting their reasons and grounds. And if there is merit, then they are upheld. If court is not convinced, you decide otherwise. And the right to be heard, my Lord, is non-derogable. Under Article 44, the right to be heard is non-derogable. I am not imposing the position of the applicants onto this court. All I'm seeking, my Lord, is that grant us space to be heard, to present the case of the applicants. And the prerogative is yours to take a decision, one way or the other. So he cannot in any way be heard to assert that I am imposing our position on the judicial officer. No. We want to present our case before court. And then a decision is made one way or the other. So it will be a travesty, my Lord, as I conclude, for this honorable court to bar us from presenting whatever case we have on behalf of the applicants for court to hear the merits of the same. We reiterate our prayer, my Lord, that you permit us to bring these matters to your attention and you take your own decision accordingly. We do so pray.
I have very carefully listened to your submissions and what the state has responded. I will now proceed to make the following remarks and findings based on the submissions. That I have perused this file, this application, and noted that application for recusal was made, it was considered by this honorable court, and the ruling was delivered on 19th August when court declined to recuse, and the reasons are given in that ruling. Today, when the matter was coming for scheduling and directions in this bail application, Counsel Kwago raised some concerns and said that he wanted to make another application for recusal. Under Rule 6(3)(b). Now, I will just I will just address myself to Rule 8, Clause 4 of the Constitutional Recusal of Judicial Officers Practice Directions 2019. I will quote verbatim that where a judicial officer declines to recuse himself or herself, the reasons for declining shall be noted on the record and the matter shall proceed with hearing. This court indeed gave the reasons for declining to recuse on 19th August. My understanding of Rule 6B, Rule 63B, which Council Kwago is relying on, I have very carefully looked at it, and the same is addressed in Rule 8.5 of the same directions, which states that where a party is dissatisfied with the decision of a judicial officer not to recuse himself or herself, the party shall state the reasons and the hearing shall continue. It is my considered view that Councillor Kwago has already told the court that he was not satisfied with the decision of this honorable court. Hence, he wants to raise other reasons for recusal. My view is that if counsel was not satisfied as he submitted, the same has been noted that he was not satisfied with that ruling. And I have put it on record that he was not satisfied. And it is my view that since this case was coming for scheduling and directions in this application, I hereby direct that this application will proceed with hearing in the presence of the applicants on 9th October.
My Lord, before you take leave of the matter.
Yes, Council.
My Lord, before you take leave of the matter.
Yes, Council.
Actions proceed with receiving the directions and also participating
No
in the
problem.
schedule.
I am ordering the registrar to issue production warrant for 9th October.
My instructions were restricted, my Lord, to raising the concerns.
Which I have put, I have
Yes,
said I wanted to raise
but as far as directions are concerned,
yes,
I have no instructions to receive the same.
No problem. I have directed that I will proceed with this application on 9th. Their application will proceed on 9th.
My Lord, 9th is a public holiday. Come on, my Lord.
He is factors official. He is factors official.
I will change the date.
My Lord, we pray to have, my Lord, this court is not functions official because it is just an issue of giving a date, my Lord. This court is not factors official.
Yes. So you are saying it is a public holiday?
It's a public holiday. My Lord, we seek another date before or after that.
This is which date?
10th is a Friday.
Reset? Yes, reset. We are gravely concerned by the conduct of the judge in this matter. You can see his behavior is not concomitant with the dispensation of justice, and it is really disturbing to us. It's a serious matter which touches liberty and the life of our people. And these two rights, we have always said, they are the most sacrosanct. The right to life first, next one is civil liberty. And now you can imagine the way he's conducting himself. Playing around with the people's lives. You call a matter, there are concerns to be raised, and you are not ready to entertain them. In total disregard of the constitutional provisions, which dictate that the right to a fair hearing is non-derogable. When you look at Article 44, one of the rights that are absolute is the right to be heard. So all we are seeking was just audience to be heard, to present concerns of the accused persons, why this matter should not proceed before that same judge. And he was not ready to listen. Can you imagine he made a ruling blocking us from entertaining those matters? The Constitution, judicial officers, whatever practice guidelines on recusal are very clear. They provide wide latitude for any aggrieved party to raise their concerns at any time, at any stage of the proceedings. Actually, the rule we cited and other rules clearly state that in the course of the hearing, you can raise as many applications as possible, depending on the circumstances and the conduct of the judge. If a judge conducts himself in a manner that is not in tandem with the dictates of the Constitution and the conduct of the judges, then you, or rather judicial officers, then you are at liberty to raise those matters. Even if you raise as many as possible, 1,000 applications, it's within the within the purview of the law. Now he has blocked us from raising the concerns of the accused persons, whose fate lies entirely in his hands. Because his duty is to listen. After listening, he takes a decision. We had grounds totally different from the earlier ones raised. And the rule provides for grounds which can arise in the course of the hearing. You ask yourself, supposing in the course of the hearing, he makes a sweeping statement which is prejudicial to the rights of the accused persons, and he claims that we are precluded from raising those matters since we made one earlier which he dismissed, and then that is an absolute ban now to raising any matter concerning his conduct. This is a matter we cannot take lying down like this.
Lord Mayor, we had a concern. What are the reasons?
The reasons, we had 3 grounds to raise here. Number 1, the file is wrongly before him. The main case is supposed to be before the Constitution, the ICD. The main trial is supposed to be conducted at ICD.
International.
That International Crimes Division.
Yes.
According to the indictment, that was signed by the DPP. Rather, the indictment, that was signed by the DPP, and the charge sheet in the lower court, the file is supposed to be committed to the ICD. That's where actually it was committed by the magistrate, the chief magistrate of Nakawa, Christine Nanteg. She committed the file to the ICD for trial. So you cannot again arrogate yourself powers to purport to conduct a hearing of a matter here when the file is supposed to be, and the application arises out of that matter. That is 1. 2, the judge made statements in his earlier ruling that Dr. Besigye and Obed Rutale are wasting time on applying for bail. Instead, they should concentrate and focus on the main trial. In his earlier ruling on recusal, he didn't say anything about that. He never ruled on that matter, which we are insisting is a matter which clearly brings out his prejudice, that he's biased in this matter. He has a predetermined mind as far as this application is concerned, because when he was considering the application for mandatory bail, he made that sweeping statement, which is prejudicial, that Besigye and Obed Rutale should stop wasting their time on applying for bail. Instead, they should concentrate on pushing for the hearing of the main case. And he never ruled. Go back and make a reference to that application. Wanted to draw his attention to that ruling he made. He never addressed his mind to that issue. So how do I appeal on a matter where you have not made a decision? Even a lay person knows that. A non-lawyer knows that unless a matter is decided upon, you cannot go to an appellate court. So this is a matter we wanted to raise before him. The third one is about the practice of this court. A judicial officer who handles a bail application in the first instance and dismisses it or declines to grant it cannot entertain a subsequent one. That has always been the practice here. It's the reason when we appeared before Justice Kanya Comfort and she declined to grant Dr. Besigye bail, she never entertained any other application. If it were to be one judge insisting on hearing all the bail applications that we present here, actually this file should be before Comfort. She's the one who had the first one. Why is it that Justice Comfort Kanya is not the one handling it, yet she's the one who handled the first one? So if we were to go by that precedent and the practice in this honorable court, then the very reason Justice Baguma should recuse himself from this matter and say, I've already made my decision on this. Rather, what actually a reasonable judge would do under the circumstances, he would make a decision and say, please, I've already made my decision on this. I have my opinion on whether Dr. Besigye and Obedi Lutale should be given bail or not. And in the interest of justice, I cannot proceed to entertain any other application, just like a Comfort Kanya did.
Lord Mayor.
Those are the three reasons.
Because
of course we had other reasons that were raised in the early application.
what is your comment about you, lawyers, transacting criminal?
They should appear.
So
and
what
that is
happens
actually
to
the last
earlier
issue,
proceedings?
the last issue I would like to address my mind to. Our instructions here were to raise these concerns. And it is the reason Dr. Besigye is not here. Now the judge has made a very, very obnoxious decision that they should appear physically here on the 9th.
Of October?
9, yes, for me, I've not heard of any other date. And I don't want to hear anything from anyone. I was there, the judge made a directive. And we are here for directions anyway. That's what he said. He gave a direction that this matter should be fixed for 9th October, which is a public holiday, which he knows actually is Independence Day. And he directed the registry to issue a production warrant for Dr. Besigye to appear on 9th
October.
9th of October. That's the direction he has given to the registry, that the production warrant should read 9th October and that Besigye should be driven here on 9th of October. That's what he said. And going by his own ruling, if a decision is made by court, they can't change it. That's what he said. That once he has pronounced himself on the matter, yes, like he ruled on recusal. He said he had pronounced himself on the matter, he couldn't sit in his own decision. Now he's shifting the goalposts. In this one, he heard that, hey, he said, hey, now, let me change it. Can you imagine? So, Dr. Besigye will not be here. Let me be on record. Dr. Besigye and Obedi Lutale will not be here on that date of 9th of October, which he has set. And the judge, we insist, should take this matter back to the registry for reallocation. That is our position. The position of our clients is very clear that this matter should be sent back to the registry for reallocation to another judge. They are not going to appear before Justice Baguma on that matter. And that is the position. Tebagenda kujja maaso ga Baguma kwezi ennaku z'omwezi omwenda October zagambye, era ffe tulemeddeko tugamba Baguma kwata fayiro agizze mu registry egende bagiwe judge omulala. Ensonga tuzirina, twamugambye ng'oggyeko ziri ze twaleeta n'azigaana, olwaleero tuzze n'ensonga endala 3. Esooka main file eri mu International Crimes Division ye ICD teri maaso ge, era n'ekiwandiiko kye bayita charge sheet oba indictment ekolebwa DPP empaabi baateekamu nti omusango gugenda mu ICD International Crimes Division. Ne Christine Nantege magistrate wa lower court kye yagamba nti file egende mu ICD. Baguma atuula wano alemedde file nga mu kifo kyo giweereza mu ICD. Ekyo tetugenda kukikkiriza. Ekyokubiri, Justice Kanya Comfort ye yasooka mu musango guno nasa bail application n'agigoba naga yadde Dr. Besigye otuukiriza ebisaanyizo byonna naye nze nkumye bail. kakati enkola ya kooti ebaddewo era etakyusibwanga omulamuzi asooka kasita akumma beiru toddayo mu maaso g'omulamuzi y'omu tubibaddemu bangi emirundi mingi ne bwe twali mugwase wanyana ne Sejjirinya e Masaka gwasooka wa Justice Victoria Nakintu bwe yaba mu beiru gwagenda wa Justice Nsengundi Muganza
Victoria aba wa beiru
jokoke no luvanyuma Justice Muganza so ebyo webito webiri omulamuzi asooka bw'akumma beiru taddamu kuwulira musange application ndala ye practice ebaddewo kati Baguma yagaana beiru eya mandatory. Imagine omuntu aganye mandatory beiru ate adde mu maaso go ogambe nti agenda kulira gye bagamba eri discretionary nga ye alina okusalawo akuwa batakuwa. Ensonga yakubiri eyokusatu kwe kuba nti nno mu ruling eyasooka ku beiru Baguma yagamba Besigye n'Obedi Lutale abawa amagezi ebyokwewubanga mu kooti nti basaba beiru babiveeko bagende balwane kulaba nga omusango main case yewulirwa. Kakati ate oyo atandika atya okulira bail application huuba wasazeewo dda nti actually bamala bya mu bulago okwewubanga mu kooti nga basaba beiru so otandika otya okuwoleza mu maaso g'oyo n'osaba beiru kitumugamba nti gobanga olina mind eyasalawo edda nti Besigye amala budde okujja asaba beiru therefore omusango guveemu gulekera omulala ye aliredde okuwuliriza. Ekisembayo kwe kuba nti anyoomye ssemateeka kitulumye nnyo okulaba nti Justice Baguma anyoomye ssemateeka muyisizaamu amaaso n'olugaayo. Ssemateeka agarantinga right to a fair hearing eddembe ly'omuntu omuwuliriza omulamuzi alina obuvunaanyizibwa okumpuliriza oba byenjogera birimu amagezi oba temuli magezi oba byagala oba tabyagala. Omulamuzi tayinza kugamba sijja kuwulira nganye iyi wuliriza ensonga zaffe zetuleese ba clients bali luzira tebaliiwo batutisse tuli ensonga tuzireete tuziteeke maaso go okusalawo kuku era tutwagala mukakaaza n'asalawo atya naye n'okutuwuliriza aganye nti sijja kuziwulira ekyo tekiriiyo. Kakati ezo z'ensonga zennyini ezikulaga nti eno terigiri bwenkanya mu maaso ga mulamuzi oyo Baguma era ffe ensonga zino tugenda kuzongerayo okulaba nga Baguma ava mu musango guno gugende omulamuzi omulala. Ruling y'omulamuzi ebadde very clear. Agambye 9th October. Agambye ffe tubadde tetuliiyo nze sinnawulirako nga 8 atutadde ng'agambye awadde directions nti Besigye ne Obedi bajja baleetanga ennaku z'omwezi 9 era agambye registry ekole production warrant ebabaleetenga 9 akizeemu emirundi mingi. Kakati mpuliddeyo abakola olwogolo nti eyo sebo eyo 9th October Independence Day public holiday simanyi birala bizeeko nze mbadde nfulumye. Kakati directions bw'abanga alina endala z'akoze azikoze ku lulwe ffe tetumanyi tugambye 9th October katulinde production warrant ya 9th October naye nga Dr. Besigye obviously tayinza kubeera wa Obedi Lutale nga 9 October kuba public holiday ate n'ensonga zetuwadde wano lwaki omusango n'alina okuvaamu.
Betunga mu baffe nazo
Wanje.
Ngenda Kanyanya.